वही तो ढूंढ रहा हूँ उसको, कहाँ है?
Make a request to all respected invitees to take their seats. Okay.
तुम अपना कर लो।
I request all the respected invitees to take their seats. Okay, done.
What do you want to say?
I kindly request all the respected invitees to take their seats. All respected invitees to take their seats.
Hello, I kindly request the respected invitees to take their seats, please.
ठीक है, थैंक यू। तू यहीं रहेगा। I kindly request all the respected invitees to take their seats.
Please ask the volunteers to occupy the seats which are lying vacant. They are standing here only. Some of them.
The volunteers.
Volunteers, now they can sit because now nobody is expected. So seats which are there, even the named seats they can occupy. Ask them to. Yeah.
Don't announce. Not by announcement. Just go and tell him. Don't do that.
Standing there should take their seats. Okay, all the
क्या करें? Inauguration.
All those who are standing, please take a seat.
All of you are please requested to take your seats.
once again request all to take their seats, and after 2 minutes I'll bring you.
The conference is about to start. Kindly take your seats. Good afternoon to one and all. We are honored to have amongst us Chief Justice of India, Honorable Dr. Justice Dhananjay Yashwant Chanchud, Honorable Justice Sanjeev Khanna, Judge Supreme Court of India, Dr. Marcin Cheblak, Secretary General Permanent Court of Arbitration, Mr. R. Venkataramani, Attorney General for India, Honorable Ms. Justice Indu Malhotra, former Judge Supreme Court of India and currently Member of Permanent Court of Arbitration, Mr. Kapil Sibbal, President, Supreme Court Bar Association, Ms. Anna Jubin Brett, Secretary, UNCITRAL. On behalf of the Honorable Chief Justice of India and the Secretary General of Permanent Court of Arbitration, we extend a very warm welcome to all the judges, distinguished invitees, and dignitaries present here today. It is an immense honor and privilege to welcome you to this inaugural program of the Conference on International Arbitration and the Rule of Law. We are gathered here today to commemorate two significant milestones: 75 years of the establishment of the Supreme Court of India and 125th year of Permanent Court of Arbitration. The event is jointly hosted by the Supreme Court of India and Permanent Court of Arbitration in collaboration with the UNCITRAL. The primary objective of this conference is to facilitate meaningful debate between the judiciary, legal practitioners, the arbitral institutions, and international organizations. We are here to tackle current challenges and explore effective solutions to streamline the arbitration process. This gathering brings together brilliant minds from the arbitral community across the globe. Your presence here underscores the importance of our shared commitment to advancing legal excellence in arbitration. Without any further ado, now I would like to invite Honorable Justice Indu Malhotra, former Judge, Supreme Court of India, and currently a member of Permanent Court of Arbitration, for the welcome address. Over to you, ma'am.
Honorable the Chief Justice of India, Dr. Justice D.Y. Chandrachud, Honorable Justice Sanjeev Khanna, Justice Supreme Court of India, Judges of the Supreme Court, present and past, Honorable Judges from the various High Courts who have come here to attend this event, Mr. R. Venkataramani, the Attorney General for India, the Solicitor General of India, even though he is not here in absentia, the Additional Solicitor Generals of India, Mr. Kapil Sibbal, the President of the Supreme Court Bar Association, His Excellency Dr. Marcin Cheblak, Secretary General, Permanent Court of Arbitration, Ms. Anna Jubin Brett, UNCITRAL Secretary, Mr. Damu Ravi, Secretary in Economic Relations, Ministry of External Affairs, distinguished guests from various jurisdictions who have come here to speak and participate in the 4th PCA India Conference, members of the bar, ladies and gentlemen, my warm greetings to all of you. I am honored to deliver the opening address on the momentous occasion of the 75th year of the establishment of the Supreme Court of India and the 125th anniversary of the Permanent Court of Arbitration. The PCA was the first permanent intergovernmental organization to provide a forum for resolution of international disputes through arbitration and other peaceful means. The PCA was established by the Convention for the Pacific Settlement of International Disputes, which was concluded during the First Hague Peace Conference in 1899. The PCA provides services for the resolution of disputes involving states, state entities, intergovernmental organizations, and investor-state arbitrations. The Republic of India became a member of the PCA in 1950 by becoming a contracting party to the 1899 Convention. On 19 September 2008, the PCA and the Republic of India signed the Host Country Agreement. The PCA has signed similar agreements with various countries in order to make its dispute resolution services more widely accessible. Through host country agreements, the host country and the PCA establish a legal framework under which PCA-administered proceedings can be conducted within the territory of the host state. Under the host country agreement, the Government of India has provided office and meeting space to the PCA, which is currently under construction in the V.K. Krishna Menon Bhavan across the Supreme Court. The first PCA India Conference was held in 2017 at the initiative of late Mr. Fali Nariman, who played a pivotal role in furthering the objectives of the PCA India Host Conference Agreement. The subsequent editions of the conference were held in 2019 and 20. After a break in 2021 on account of COVID, a workshop was organized exclusively on investment treaties in 2022 for capacity building by engaging experts from India and overseas. We are now holding the 4th PCA conference this weekend. The PCA has conducted several politically sensitive cases across the world, and I will cite 3 of them with respect to India. The first was the interstate arbitration between Pakistan and India arising out of the Indus Water Treaty in the Kishan-Ganga arbitration. Mr. Nariman represented the Republic of India without charging any fees and described it as his duty to the nation. It is heralded as a success for both Pakistan and India and is cited as an example of peaceful resolution of international disputes, particularly where there were strained and disturbed relations between 2 neighboring states. Interestingly, this is a rare case where there was a 7-member tribunal constituted from diverse backgrounds of jurists, and there was no one who was representing the contesting states in the tribunal. The tribunal passed a unanimous award, which is being followed to date by both the states. The second one was the arbitration between India and Bangladesh under the United Nations Convention on Law of the Sea, which is known as the Bay of Bengal Maritime Boundary Arbitration. The award was passed by a 5-member tribunal in 2014, establishing the course of the maritime boundary line between Bangladesh and India. And more recently, the PCA administered what is popularly referred to as the Italian Marines case, and I must mention that now Justice P. Narasimha, who was then Additional Solicitor General, had represented the Republic of India in this case. The case pertains to the killing of 2 Indian fishermen by 2 Italian Marines on board an oil tanker. A 5-member tribunal passed a unanimous award in 2020, wherein it was held that India was entitled to compensation in connection with the loss of life, physical harm, material damage to property and moral harm suffered by the captain and crew of the Indian vessel. On the issue of jurisdiction, it was ruled that as per the territoriality principle, both Italy and India were entitled to exercise jurisdiction over the incident, since the offense was commenced on board the Italian vessel and completed on board the Indian vessel. However, it was held that India was precluded from exercising its jurisdiction over the Marines, Italian Marines, since they were entitled to state immunity because they were on a vessel with the Italian flag. At present, India is going through a transitional phase in its investment treaty program. Historically, India signed its first bilateral investment treaty in 1994 with the United Kingdom. Post the 1991 economic reforms and up to 2015, India signed up BITs with 83 countries. The BITs were based on the Indian model BIT text of 1993, which was based on the basis of the contemporary international precedents. It is towards the end of 2011 when the first adverse order was passed against India in the White Industries case, which resulted in the government reviewing its entire investment treaty regime, particularly since it has resulted in a spate of claims being filed against the Republic of India. All these claims are based on the first generation treaties. The government issued termination notices to the countries with whom the initial treaty period had ended. However, claims continue to be filed under the sunset clauses of these treaties. The earlier model was revisited and a new model text has been adopted in 2015. In the model BIT of 2015, the default power of appointment has been conferred upon the Secretary General of the Permanent Court of Arbitration, where the arbitrations are conducted under the UNCITRAL rules. India has recently signed a unique agreement with Brazil, which is quite a unique model where there is no ISDS clause, but it provides for a joint committee to resolve disputes of investors in both the countries, and in case there is a failure, then there can be a reference to an ad hoc interstate arbitration. It's a vexed issue, and these issues are being deliberated and discussed in various fora as to what are the alternates or what is the reforms required in the ISDS system. With this, I welcome all the dignitaries on the dais and off the dais to the 4th PCA India Conference on International Arbitration and Rule of Law, and I hope that it will give an opportunity to have a meaningful discussion and interaction between the participants and the deliberations on the same, on various subjects which have been slated during the next 2 days. Thank you.
Thank you so much for your insights, Justice Malhotra. Now, I would like to invite Mr. Kapil Sibbal for the address. Over to you, sir.
Chief Justice of India, Honorable Justice D.Y. Chandrachud, Honorable Justice Sanjeev Khanna, Judge of the Supreme Court of India, Dr. Marcin Cieplak, Secretary General, Permanent Court of Arbitration, Ms. Anna Jubin-Brett, Secretary UNCITRAL, Honorable Justice Indu Malhotra, former Judge, Supreme Court of India and currently a member of the Permanent Court of Arbitration, R. Venkat Ramani, Attorney General for India, Judges of the Supreme Court, Chief Justices of the High Court, Judges of the High Court, Supreme Court, senior advocates, members of the bar, ladies and gentlemen. This is indeed a seminal moment in every sense of the word because we celebrate not only 75 years of the establishment of the Supreme Court of India, but also 125th anniversary of the Permanent Court of Arbitration. The Permanent Court of Arbitration provides administrative support in international arbitrations between states, state entities, international organizations, and private parties. Further, the Secretary General of the PCA may be called upon to act as the appointing authority or to designate another appointing authority for the appointment of arbitrators under the PCA's rules of procedure, the UNCITRAL arbitration rules, or other rules of procedure. It also provides hearing facilities and support in other forms of peaceful resolution of international disputes, as well as administrative support in fact-finding commissions of inquiry. With a population of 1.4 billion people and a growth rate of over 6%, India is one of the fastest growing economies in the world. There are investment opportunities in multifarious sectors of the economy. Given India's vision of becoming a $5 trillion economy by 27-28, foreign direct investment is destined to play a role in seizing economic opportunities where capital earns sizable returns and the domestic economy is given a boost. Efficient dispute resolution through international arbitrations is thus essential in fostering such investments. Commercial arbitrations and investor-state dispute settlement, called ISDS, mechanisms have an instrumental role to play in India's growth story. The rule of law being adhered to in these international arbitrations is necessary to promote investor confidence consistent with India's aim to be an international arbitration hub. The title of today's conference is International Arbitration and the Rule of Law. The rule of law, a constitutional principle, has a pivotal role in particular in international arbitrations. Lord Neuberger in 2015 stated, and I quote, "Arbitration is not simply compatible with the key features of the rule of law, but that it has an increasingly important role to play in upholding those key features both nationally and internationally," close quote. While it is not possible to limit the definition of the rule of law, Lord Bigham gave a famously compact overview of the rule of law in his seminal Sir David Williams lecture at Cambridge University in 2006, and I quote, "The core of the existing principle," he argued, was, and I quote again, "that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts," close quote. The principle of the rule of law is enunciated in Section 18 of the Arbitration Act, and largely the Supreme Court has been instrumental in upholding this aspect of the rule of law in arbitration. However, there have also been blips on the radar which have sent a negative signal. In some situations, an arbitral award is upheld by all courts in India. However, the process of execution is so dilatory, the very objective of expeditious resolution is lost. Therefore, it's necessary that within the judicial hierarchy at all levels, the significance of expeditious resolution in these matters is understood and acted upon. Further, I have been hearing murmurs of India's supposed withdrawal from the investor-state dispute settlement regime. This characterization, however, is misguided. Rather, a more nuanced view reveals India's endeavor to redefine its position within the global economic order. The BITS, that's the bilateral investment treaty regime, are being renegotiated to ensure a level playing field which will foster growth in India. It's also necessary for India to realize that foreign capital will play a significant role in its investment story. Thus, the investment landscape must be made increasingly fertile, at the same time allow for a level playing field. The fact that the FDI flows in India have been reduced by 30% from 2013 to 2019 as compared to other countries is perhaps attributed to the terminations of the bilateral investment treaties. An investment treaty crafted with a just and balanced perspective will herald a seismic shift, with the Global South asserting itself more forcefully in shaping the very legal framework that shall govern their economic destinies. A just bilateral investment treaty environment will be a win-win for both investors and nations. Just as the investors need us, we too need investors. Thank you very much.
Thank you for your remarks, Mr. Sibbal. Now, I would like to invite Ms. Anna Jubin Brett, Secretary of UNCITRAL, to the podium.
Honorable Chief Justice, Honorable Attorney General for India, Excellencies, Judges of the Supreme Court and High Courts of India, distinguished participants, speakers, colleagues, and friends of UNCITRAL. It's my great honor to deliver these inaugural remarks for the 75 years of the establishment of the Supreme Court of India and 125th anniversary of the Permanent Court of Arbitration, co-hosted by the PCA with the Supreme Court of India in collaboration with UNCITRAL, with many thanks to the co-organizers for this privilege that is given to me to welcome you all here on behalf of UNCITRAL. I'm delighted to be among friends on such an auspicious occasion, 75th and 125th, as my good friend Martin Shepalak says, it's 200 together. Anniversaries are not easy feats, and the long-standing tradition of India's judicial system is to be applauded. As guardians of the law, judges comprise UNCITRAL's key stakeholders, and most importantly, are among those who best appreciate that UNCITRAL's mandate of advancing harmonization of international trade law in practice requires that the laws concerned are interpreted and applied in a uniform manner. To support consistency in decisions and awards on its texts, UNCITRAL established a system to collect and disseminate freely available information on courts' decisions and arbitral awards from around the world relating to UNCITRAL texts. The case law on UNCITRAL texts, also known as CLOUT. I take this chance to salute India's valuable contributions to the case law on UNCITRAL texts, with many cases from India focusing on the model law on international commercial arbitration and the New York Convention being part of this collection. This could not be achieved without a well-informed judiciary which considers the international origin of the law and the need to promote uniformity in its application in interpreting the texts concerned. And this brings me to a note of sadness. While I'm delighted to be here 1 year after the UNCITRAL South Asia conference that was held last year with the Ministry of External Affairs, and this sadness goes to the passing of Fali Nariman, who was one of the most strong advocates of UNCITRAL's work here in the region and beyond. So, sir, we miss you. As the time is short, I will take this opportunity to share some brief updates from UNCITRAL, focusing on those relating to arbitration and investor-state dispute settlement, as I know you are anxious to know what is next on UNCITRAL's menu for the reform of ISDS. The work of UNCITRAL in developing a fair and efficient resolution system contributes to the achievement of the Sustainable Development Goals of the United Nations by enhancing access to justice and strengthening the rule of law, one of the founding topics of this conference here, as it reduces the time and cost to resolve disputes and relieves the burden on the judiciary and formal legal system. In addition, enforceable and effective solutions between parties to cross-border commercial disputes resulting from the UNCITRAL dispute resolution frameworks contribute to the development of a mature, rule-based global commercial system. This July, the 57th session of the UNCITRAL Commission in New York adopted 4 new substantive texts and agreed on a future work program for the Commission. It adopted a statute of the Advisory Center on International and Investment Dispute Resolution. As UNCITRAL continued its work on possible reform of investor-state dispute settlement, a major milestone in this development is the establishment of an advisory center to support developing countries in order to address inequality of means in terms of access to resources as well as legal services concerning international investment dispute resolution. A further element of the broader reform of the investor-state dispute settlement system undertaken by UNCITRAL, once established and operational, this center is expected to provide crucial legal services in the field of ISDS, akin to the system that has been established alongside the World Trade Organization to help developing countries fully benefit from the dispute settlement system of the WTO. This center will include training and representation services with the aim of enhancing the capacity of states to prevent and handle international investment disputes, especially least developed countries and developing countries. The Commission also adopted UNCITRAL model clauses on specialized express dispute resolution. It sounds better in its acronym SPEEDER, which includes provisions on technical expertise, on confidentiality for highly sensitive technical disputes, but also on adjudication and on contract performance. These model clauses will be available to parties that they can choose from when they want to go for the UNCITRAL expedited rules. UNCITRAL has also adopted a model law on automated contracting, which provides a legal framework to enable the use of automation in international contracts, be it through the now buzzword of artificial intelligence or the so-called smart contracts, but also what we see on a daily basis, machine-to-machine transactions. And last but not least, UNCITRAL adopted the UNCITRAL Inaugural model law on warehouse receipts, which allow the issuance and transfer of both paper-based and electronic warehouse receipts in a medium-neutral and technology-neutral basis to allow the use of central registries, distributed ledgers, platforms, and other technologies for the managing of electronic warehouse receipts. Now, to answer a question that panel 1 will be answering tomorrow and that I will unfortunately not be able to contribute to, are we close to a solution in ISDS reform? I would venture that we have made great progress and that indeed we are moving closer as we come now to the development of two crucial reform elements, one being the establishment of a court, a first instance court for investor-state disputes, and the second being the establishment of an appellate mechanism, again patterned on what is well known in the World Trade Organization's dispute settlement understanding, but that has been lacking so far in investor-state disputes. At the same time, the working group will also consider and the Commission adopt the procedural rules reform that is ongoing, which will not result in further atomization of rules, as has been feared with the efforts being carried out by ICSID and resulting in the ICSID rules amendment, but simply to mirror and to bring to the level of the investment treaties themselves the reforms in procedure that are dearly needed in order to expedite and further control the costs of these proceedings. So with all these news for you that we hope you will be following closely, let me tell you that from the discussions that will unfold during the 2 days of this highly interesting and topical conference, we hope in UNCITRAL to see proposals coming from India to the UNCITRAL Commission on the development of legislative solutions, the ones that you see are needed, bring them to UNCITRAL, bring them to us for deliberations at the international level, discussions with your peers from other countries in order to come up with harmonized and uniform solutions. I look very much forward to our invigorating discussions over the course of the conference on how we could work together to strengthen a legal enabling environment for international trade in India and beyond, with gratitude again to our co-hosts, the Ministry of Justice, the Supreme Court of India, the Ministry of External Affairs, and the UNCCI, thanking you once more for this honor and best wishes for a most successful conference. I thank you very much.
Thank you, Ms. Anna, for informative and insightful speech. Now, I would like to call upon Mr. R. Venkataramani, Attorney General for India.
Firstly, it's a day of rejoice for me, in the sense that we have the Permanent Court of Arbitration, a 125-year young institution represented by equally young Secretary General. It's a day of rejoice for me because India has offered a welcome place for PCA in India, and I hope very soon a wonderful building which PCA will occupy and start the deliberation will be available for PCA and all of us to share. Just across the road, the Indian Society of International Law building. So that's a day of rejoice for me. And yesterday, as you were talking to Anne, and as I said, Ancitral is just half of 125, 60 years. So I was talking to her, I think it's time that India celebrates Ancitral's role for the world of arbitration, and I think India is poised so well to do that. I think we are planning on that. I'm sure we'll work on that lines. Now, Honorable the Chief Justice, judges of the Supreme Court, judges of the High Court, and distinguished invitees, my learned friend Mr. Kapil Sibal, and Senior Counsel, and greetings to all the accomplished persons in the field of international arbitration gathered here today to share compacts and understanding and pronounce upon the ever-needed values of enhancing the role of the arbitral world in emerging global situation. This conference has significance both for India and PCA, as I said. Way back in 2008, PCA and India signed a treaty-level host country agreement. This policy of PCA of concluding host country agreements has been seen as an important measure towards making PCA's dispute resolution services more widely accessible. While PCA has several host country agreements today, India was the fourth state in which PCA signed its host country agreement. That the importance of the exchange of knowledge and experience is very indispensable today, having regard to the fast-changing global economic, social, and international relationships need not be underscored. We are homo technologicus today, and our economic and trade are technologically embedded. So our dispute resolutions, their places and procedures call for global cooperation. Through the good offices and efforts of late C. Fali Nariman, the first India PCA conference was held in 2017, followed by a second edition of the PCA India conference in 2018. After a long gestation, India has now facilitated the presence and the office of PCA in India. As I said, very soon, all formalities in the regard will be concluded. So it is, I say, that this conference has significance. Given India's commitment to all aspects of the promotion of orderly and peaceful resolution of both interstate and other private disputes, it is to be stated that India's commitment to exploring and supporting all possible means, measures, instrumentalities, and provisions stands undersigned with a seat for PCA in India. The story of PCA over 125 years of enduring existence is a chronicle of excitement, and Gilbert Guillemets, former president of ICJ and member of the Permanent Court of Arbitration, in an address on the contribution of PCA, looked at the diverse domains of arbitration which are served by PCA in the past, namely financial, environment, territorial, and he asked this question. This was the past. What does the future look like? There is no doubt that calling upon judges and arbitrators to settle disputes between states has experienced a true regeneration over the last 2 decades. Will this trend continue in coming years? Will the International Bureau of PCA continue to benefit from this trend? It seems to me that we have good reason to hope so, end quote. This conference, like all the engagements of PCA in international understanding of the arbitration world, are an endorsement of that fond hope. Inaugural sessions are like several station masters waving green flags for an exciting train journey. V.V. Vidar, universally known as Johnny, was a remarkable figure in the world of international arbitration and commercial arbitration and investment arbitration. I quote from one of his articles on the importance of free spirits in the search for international arbitration. I quote, "As a philosophical question of seemingly high importance for the modern state of international commercial arbitration, the question is frequently asked by many, which came first, the arbitral egg or the arbitral chicken? The egg-loving tribe proclaim the egg as the great egg as the exclusive source for all that is good in arbitration. Conversely, the chicken-loving tribe contend that the big chicken laid the first arbitral egg. Other arbitral tribes disagree with both." I quote, "The beauty of celebrating 125 years of PCA is the beauty of free spirits in not only asking questions, as Vida talked about, in the enhancement of the value and quality of international arbitration, but also bringing together all arbitral tribes in the Vasudeva Kudumbakam tradition to continue to talk about agreements not hindered by disagreements." I must conclude by placing my deep appreciation of the relentless efforts of Honorable the Chief Justice in designing this conference and inviting all of us to be partners in the common quest. I hope the two-day deliberations will be in furtherance of the common quest. Thank you so much.
Thank you, Mr. Venkataramani, for the speech. Now, I may kindly request Honorable Justice Sanjeev Khanna, Judge, Supreme Court, for the address.
Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Ms. Justice Indu Malhotra, former Judge, Supreme Court of India, and Member, Permanent Court of Arbitration, Dr. Heb Mekin Zeplak, Secretary General, Permanent Court of Arbitration, Ms. Enna Jobin Bayet, Secretary, Unicitral, Mr. R. Venkataramani, the Attorney General of India, Mr. Kapil Sibal, the President of the Supreme Court Bar Association, judges from Supreme Court and the High Courts, and distinguished guests, Namaste and good evening. Today, as we celebrate 125 years of the Permanent Court of Arbitration and 75 years of the Supreme Court of India, we are reminded of the foundational principles that guide these institutions, pursuit of accessible and impartial justice. Justice in primary sense means and requires existence of rules that provide the right to a fair and a just decision, a procedure that provides equal and a fair opportunity to win against your opponents. Adjudication is not an end by itself. Adjudication should not be equated with the rule of law. Object and purpose of adjudication and rule of law is to ensure a just and a fair outcome and decision through a procedure free from influence of extraneous elements and internal prejudices. While media and political leaders often talk about maintaining political world order, adjudicatory interdependence is seldom focused and deliberated upon. Judicial interdependence is an acknowledgement of the need for global collaboration or for resolution of transborder disputes and issues. Just as disputes are natural to humans, so is their resolution. We should begin by the age-old tenets of judicial comity or amity. These are practices among different states or courts of different jurisdiction involving mutual recognition of legislative, executive, and judicial acts. It is a cooperation of various judicial systems around the world which will ensure uniform application of law to the best extent possible. One of the key features of judicial committee is establishment of alliances between different judicial systems to ensure higher efficiency of legal proceedings at the global level. The concept of justice is enriched by learning from experiences and innovations from judicial institutions across the globe. Let us look at the Indian example. Not too long ago, there were questions raised whether democracy and constitution will thrive in all societies. Indian colonial rulers justified their rules by highlighting the society's perceived fragmentation, arguing that democratic individualism was incompatible with such diverse society. India showed that to the world that this is possible. To achieve this ideal, the Indian Supreme Court is bequeathed with wide and expansive jurisdiction by the Constitution. Today, this court handles the largest volume of cases in any apex court globally. In 1950, when it was first established, the court had sanction strength of 8 judges and pronounced 43 judgments in its first year. Today, the court has a strength of 34 judges and pronounces more than 1,000 judgments per year. This court does not sit as a full court. The court typically sits in smaller benches of 2 and 3 judges. Despite the need for consistency and certainty, this ensures diverse representation and acknowledges various perspectives within the judicial system. Nevertheless, there exists an harmony, coherence among the benches, contributing to the evolution of law and establishment of precedents. It makes the court widely accessible and prioritizes accessibility to common citizens of our country. This court has a rich history marked by groundbreaking decisions that resonate with the aspirations of the constitutional founders. In response to challenges to access to justice, the court has proactively developed innovative remedies even beyond the traditional constitutional role to ensure complete justice in individual cases. This is done by exercise of power under Article 142 of the Constitution. Sometimes personal grievances were hindered by limited resources available to citizens, restricting the access to court. To address this and also to address broader constitutional issues, the Supreme Court introduced public interest litigation, allowing any citizen or a social action group to approach the court on behalf of general public or marginalized sections of the society. Judicial review, far from being one-sided, has fostered a collaborative dialogue between the judiciary and the other wings of the government. For instance, the Supreme Court landmark decision in Visakhapatnam versus State of Rajasthan sparked a national conversation on sexual harassment, leading to an enactment of laws to protect women in workplaces. In India, our trial and appellate courts presided over 26 million cases in 2023. Adjudicatory performance is often tested on daunting challenge of case backlog. Every judicial system grapples with this challenge, which is not only delays justice, but also erodes public confidence in the justice and legal system. To tackle this problem, Indian judiciary has turned to innovative solutions, blending modern legal frameworks with traditional methods of dispute resolution from Indian villages. Among these, Lok Adalats of People's Court, which operate outside conventional courtrooms, focusing on informal reconciliatory dispute resolution, stand out as a remarkable innovation. The success of Lok Adalats is a testament to their effectiveness. In last 6 years alone, they have resolved about 130 million cases, underscoring the capacity to reduce the backlogs. During the coronavirus pandemic, when physical courts were largely inaccessible, introduction of e-Lok Adalats brought these forums online, resolving over 7 million cases. India's experience with Lok Adalats and community mediation offer valuable lessons for global community. Arbitration is a leading method for resolution of commercial and international disputes. In line with these global trends, India has enacted several reforms to position itself as an arbitration-friendly jurisdiction, resulting in notable improvements in contract enforcement and ease of doing business. In FY 2014-15, FDI inflow in India stood at 45.14 billion, which increased to 60.22 billion in 2016 and 17. In FY 2021 and 2022, the FDI inflows increased to 84.83 billion. At this juncture, I'd like to also take this opportunity to acknowledge our association with the UNICITRAL in its long and enduring development of law of arbitration. The 1996 Arbitration and Conciliation Act is modeled on the UNICITRAL model. Later amendments to this act have brought Indian arbitration regime in line with international parlance. We have adopted and accepted that institutional arbitration should be preferred over ad hoc arbitration. We have speeded up arbitration by prescribing time limits within which awards should be pronounced. We have standardized arbitration by including setting standards for appointment and eligibility of arbitrators. And lastly, we have expedited or speed up arbitration is now being accepted and is being implemented. If I have to look for the future of international dispute resolution, I must say conciliation has to become and brought into the forefront. I'll quote from Mahatma Gandhi what he had said about conciliation. Truly a person is indurate and acts cowardly when he resorts to the court of law. Surely a decision of a third party is not always right. We in our simplicity imagine that a stranger, by taking our money, gives us justice. Taking inspiration from these words, perhaps global community should consider less formal ADR methods like mediation conciliation, which are far more flexible, non-technical in dispute resolution. Namaste and thank you.
Thank you, Justice Khanna, for sharing your insights. Now, I would like to call upon Dr. Marcin Cieplak, Secretary General, Permanent Court of Arbitration, for the address.
Namaste. Good evening. Honorable Chief Justice Chandrachud, Justice Indu Malhotra, Justice Sanjeev Khanna, Honorable Attorney General Venkataramani, Mr. Kapil Sibal, President of the Supreme Court Bar Association, and Your Excellency Anna Jobin-Brett, Secretary General of UNCITRAL, distinguished guests, ladies and gentlemen, dear friends. It is my great pleasure and honor to extend a very warm welcome to all of you on behalf of the Permanent Court of Arbitration, the PCA. This year marks a momentous occasion as we celebrate together 200 years of service to the rule of law. On one side, the Supreme Court of India celebrates its 75th anniversary, and on our part, 125 years passed since the PCA was established in 1899 by the First Hague Peace Conference. To commemorate these significant milestones, the Supreme Court of India and the PCA have joined forces to organize this special event. It is an opportunity to celebrate the rich legacy of these two distinguished institutions, but is also to reaffirm our collective commitment to the ideas they represent: justice, fairness, and the rule of law. As I have just mentioned, the PCA is an intergovernmental organization established by the 1899 Convention on the Pacific Settlement of International Disputes. It is headquartered at the Peace Palace in The Hague, in the Netherlands. The idea behind creating the PCA, and I hope that I will be able to speak more about it tomorrow, was to provide a solid framework for international dispute resolution, mainly arbitration, but also various other forms of proceedings, such as conciliations, mediations, multi-party review panels, fact-finding commissions, dispute adjudication boards, and many more. Few international organizations have the privilege of enduring for so long, 125 years. And even fewer remain relevant and effective in a world so dramatically different from the one in which they were founded. Since its establishment from a small institution headquartered in The Hague to one with 5 international offices in Asia, Africa, Europe, and Latin America, the PCA has witnessed the end of empires, the rise and the fall of the League of Nations, the wave of decolonization, the emergence of the larger community of states, and the creation and growth of the United Nations. Throughout 2 world wars, numerous local and regional conflicts, and prolonged Cold War, the PCA stood firm. This resilience is particularly significant in today's international landscape, which is unfortunately marked by strife and polarization. In fact, the PCA is busier than it has ever been. Allow me to share some statistics and information. Last year, we experienced a record-breaking 82 new cases registered, by far the highest number of new registry cases that the PCA has ever received. At present, the PCA has one of the heaviest caseloads among international courts. So in 2023, the PCA administrated 246 cases. Among those cases, the PCA administers interstate proceedings, investor-state arbitrations, and contract-based cases involving various combinations of states, state entities, international organizations, and private parties. Moreover, the PCA services have been used since its establishment by claimants from over 136 countries and regions, and respondents from 142 countries and regions. Over 60 proceedings have been initiated in which at least one party is an international organization. It is true, dear Honorable Chief Justice, that our numbers are a fraction of the number of cases handled by the Supreme Court of India, and maybe similar figures could be handled by a single justice alone at one day, which I witnessed today in the morning. And hopefully, at the PCA, we will never reach similar levels of activity. But just in case, I would like to have the same war room as you have at the Supreme Court. Well, jokes aside, there are a few reasons that, in my view, played a key role in the PCA success and recent growth. And the first point I would like to address is the PCA's flexibility. We owe it to our founders, who, with remarkable foresight in an era of global instability, established an organization built on the principles of flexibility and the core principle of favoring the resolution of disputes as such over rigid protocols or specific methods of dispute resolution. The second point I would like to mention is accessibility. The PCA's founding convention made it clear that the PCA shall be, and I quote, accessible at all times, end of quote. Accessibility can be achieved in various ways. Being accessible today means that the PCA needs to be able to operate everywhere. To that end, the PCA enhanced its global presence through several concrete actions, which include a policy of concluding host country agreements with its contracting parties. And these agreements seek to secure the provision of the facilities and services required for the PCA administrated proceedings, such an office or meeting space and secretarial services. The PCA concluded such a host agreement with India back in 2008. The signing of host country agreements may lead to enhanced cooperation, that is, to the establishment of an international office. And today, the PCA has offices in Argentina, Austria, Mauritius, Singapore, and Vietnam. I am pleased to announce that discussions regarding the opening of a PCA office in India have progressed. I have personally witnessed how Indian lawyers can be very firm and tough. I'm confident that any remaining differences will be resolved and that the PCA will be able to establish a permanent presence in India soon. As I said before, this occasion is to commemorate the rich legacy of both of our institutions. At this point, it is fitting to commend the Supreme Court of India for its significant strides in enhancing accessibility. It is truly an honor for the PCA to organize this event in partnership with an institution that shares our deep commitment to ensuring accessibility to justice. I'm also delighted to contribute to ongoing tradition of the PCA India conferences. These conferences have served and continue to serve as a valuable platform for a meaningful dialogue. I look forward to the debate and discussion at the upcoming sessions. Thank you.
Thank you, Dr. Cheplak, for your remarks. Now, Mr. Attorney General for India, R. Venkatramani, will make a statement in connection to the virtual launch of PCA India office situated at V.K. Krishna Menon Bhavan. Additionally, I would also like to call Mr. Dammu Ravi, Secretary, Ministry of External Affairs, on the dais.
Please come. As a very special form of enhanced cooperation between India and PCA, and thanks to the vigorous support and encouragement given by the Ministry of External Affairs, the Minister and the Secretary present here, and noting that the Government of India and PCA have jointly agreed on the location of the Office for PCA, we are happy to announce the launch of the same and its construction. I invite the Honorable Chief Justice to do the launch. And of course, before that, the Secretary General PCA will probably like to make a statement. Would you like to say something?
Let me just briefly thank and express my gratefulness to the government of India, who decided to offer the venue for the office and hearing space. It has been a long way to come to this point. It will probably be still a long way that we need to go before the office is operational. But we think together that this moment should be celebrated. This milestone must be marked. We could lay down a cornerstone, but the building already exists. So it's out of the question. It just needs to be completely renovated and refurbished. And to my great joy, and thanks to the personal commitment of these two honorable distinguished gentlemen, Mr. Damu Ravi and Attorney General Venkataramani, that the government has recently decided to, I would say, invest money in this very, very good cause and to build or to make available space with the objective of establishing the PCA India office. And I'm happy that we have come to this place and this decision has been made. And I'm happy that we also are here to celebrate this moment. I was thinking what would happen if we decided to go to the construction site and to see how the work starts in this pouring rain. So I think it's only one appropriate way of marking this and do it virtually. So I think this very auspicious moment is awaiting the Honorable Chief Justice, and we will be waiting for you.
Now, I'll kindly request Honorable Chief Justice of India, Justice D.Y. Chandrachud, for the address.
Ms. Anna Jubin Brett, Secretary of Unsatral, Mr. Marcin Chapelak, the Secretary General of the Permanent Court of Arbitration, a very distinguished sister, Justice Indu Malhotra, former Judge of the Supreme Court of India and member of the Permanent Court of Arbitration, Justice Sanjeev Khanna, Judge of the Supreme Court of India, my sister and brother judges from the Supreme Court, Chief Justices of the High Court Judges, Mr. R. Venkatramani, Attorney General for India, Mr. Kapil Sibal, President of the Supreme Court Bar Association, President of the Supreme Court Advocates on Record Association, all the office bearers, all the distinguished judges of the High Court and members of the global arbitration community who have assembled here this evening. This conference, as we've heard from different speakers, marks a significant milestone for two towering institutions, the Supreme Court of India and the Permanent Court of Arbitration. At our birth, the Permanent Court of Arbitration was getting into her middle ages. At 125, you have to reinvent yourselves, and the cells have to regenerate. I think we are following in close tandem in the Supreme Court. We are regenerating and reinventing ourselves, whether it's in terms of access to justice or in terms of the adoption of technology or the creation of new infrastructure for our court. As the Supreme Court celebrates 75 years of its establishment, and the Permanent Court of Arbitration celebrates its 125th anniversary, we couldn't have had a better occasion to do something together, which is the launch of the PCA office in India. Well, time has tempered both our institutions, testing their mettle from time to time, with both institutions proving their enduring commitment to the rule of law. The PCA has organized 5 events in India, including one capacity building training program organized in collaboration with the Ministry of External Affairs. I'd like to take this opportunity to thank the MEA and its secretary, Mr. Damu Ravi, who has really been very personally involved in this whole movement of training and evolution. I've had the distinct privilege of being a part of these events. But today's milestone conference marks a palpable sense of void. Mr. Fali Nariman, an eminent senior counsel and a doyen of the global arbitration community, passed away in February this year. Not only has the Indian legal community suffered the profound loss of a beloved lawyer, jurist, and mentor, but the global arbitration community too has lost a towering spirit and figure. Mr. Nariman was the ultimate multi-hyphenate, if I may call him so. He was the ultimate multi-hyphenate of the PCA as a council, appointing authority, and passionate advocate for its outreach efforts in India. Notably, Mr. Nariman played a key role as counsel in the PCA-administered Indus Waters Kishanganga arbitration between India and Pakistan. This case is truly heralded as a masterclass in using arbitration to resolve even the most sensitive and contentious disputes between nations with delicate relationships. There's nothing as delicate as the sharing of waters. Mr. Nariman was also the chief architect of the outreach efforts by the PCA and independent organizations such as the International Council for Commercial Arbitration in India. He served as a president of the ICCA between 1994 and 2002. Mr. Nariman is often credited with activating the host country agreement between PCA and India by spearheading the organization of the PCA India conferences. In fact, the vision to host an event celebrating the 125 years of the PCA was conceived by and championed with Mr. Nariman at the helm. Today we are realizing his shared dream, though unfortunately without his physical presence. Until the night before Mr. Nariman's passing, he was grappling with arbitration law and working on settling a draft written submission for a constitution bench hearing in the Supreme Court on the subject. Coincidentally, this is a case about arbitrator bias, which the Supreme Court reserved for judgment just a couple of weeks ago. Throughout his life, Mr. Nariman spoke with a candor that was as refreshing as it was terrifying. Who else could make you laugh while simultaneously pinning you to the wall with a piercing question? I vividly recalled his address at the UNCITRAL South Asia Conference held around the same time last year. In his characteristic style, he fired off a series of piercing questions that the Indian arbitration community continues to grapple with and find answers to. In many ways, this conference is an attempt to pay homage to Mr. Nariman by doing what would have brought him the greatest joy, relentlessly pursuing answers to the tough questions of our times and fearlessly asking new ones. The theme of this conference, International Arbitration and Rule of Law, is particularly significant. The arbitration community across the world often emphasizes the importance of commercial efficiency and ease of business, but these values are inextricably linked to a deep respect for the rule of law. Put simply, the rule of law heralds better economic and commercial outcomes. Respect for the rule of law promotes fairness, stability, and predictability. This in turn creates a conducive environment for economic growth, as investors thrive in a system where rights are protected, contracts are enforced, and disputes are resolved efficiently. A strong rule of law framework also encourages foreign investment, promotes trade, and enhances a nation's global competitiveness, ultimately driving sustainable economic development and improving living standards. The rule of law shares a symbiotic relationship with the creation of an environment which fosters economic stability and growth. Rule of law principles are, in other words, the virtual semiconductors of our digital era. The time has come for India to take the lead in fostering a culture of international arbitration, providing a level playing field for dispute resolution beyond domestic courts. And not without reason. The IMF has predicted a 7% growth in GDP for India for 2024-25, making us rank at the virtual top of the ladder. The World Bank has followed suit. Gross foreign direct investment inflows ranged at about US $71.4 billion in 2023 and about US $71 billion in financial year 2024. There has generally been a decline in global FDI. So the net FDI inflows, which stood at $42 billion in financial year 2023, dipped to $26.5 billion in 2024. According to our Department of Economic Affairs, India's overseas direct investment, ODI, stood at $33.45 billion in FY 2023, US $51.06 billion in FY 2022, and US $50.71 billion in 2021. Between April and June this year, India's ODI stood at about US $9 billion. So these figures are now a clear indicator that India is not just an importer of capital, but we are exporters of capital. We today do not stand on the cusp of a country which is fearful of the inroads of foreign direct investment, or for that matter, of human capital from abroad into India, because we are net exporters of capital, both human and economic. And that's why I said that the time has come for India to take the lead in fostering a culture of international arbitration. By establishing a robust institutional framework, India can champion the growth of arbitration in the global south, promoting a fair, efficient, and reliable means of resolving commercial disputes. I'm delighted that PCA is honoring its affinity with the Indian legal system by establishing a regional office in New Delhi under the host country agreement. The office, located right across from the Supreme Court of India, is symbolic of the common goals of both our institutions to encourage arbitration and promote the rule of law, ultimately contributing to the growth of international trade and investment in our region. I'm certain that this development will be instrumental in recognizing India as an arbitration-friendly jurisdiction in South Asia and would allow parties in dispute located in or near India to take full advantage of the flexibility and efficiency of the PCA-administered framework. Since the last PCA conference in 2020, India has made several strides towards embracing this role of becoming a global arbitration hub. I would like to take this opportunity to share some of these successes with the audience, particularly from overseas. A prerequisite for achieving commercial efficiency and upholding the rule of law is certainty. In a landmark decision in Cox & Kings versus SAP India Limited, a 5-judge constitution bench of the Supreme Court conclusively resolved the ambiguity surrounding the group of companies doctrine in the Indian context, putting to rest conflicting interpretations and establishing clear principles of law. The law in India on this point is now consistent with international practice. Indian law mandates that certain documents be stamped, indicating that the necessary duty has been paid to the Indian revenue authorities. In December last year, a 7-judge bench of the Supreme Court of India settled a question about the enforceability of an arbitration clause in an unstamped agreement. Initially, a bench of 5 judges of our court in NN Global Mercantile Private Limited versus Indo-Unique Flame Limited had held that an arbitration clause contained in an unstamped agreement cannot be enforced, and a referral court may prevent the initiation of arbitration until the underlying contract is validly stamped. Quite understandably, there was a furor in the investment community. The Supreme Court was quick to course correct, and a bench of 7 judges upheld the principles of severability and the primacy of arbitral autonomy. The court advocated for a hands-off approach by referral courts and held that the court is only required to examine the existence of arbitration agreements, leaving it to the arbitral tribunal to rule on its jurisdiction. Further, we held that the issue of an insufficiently stamped instrument is not fatal to the arbitration agreement and can be dealt with by the arbitral tribunal in accordance with the doctrine of severability. Not only jurisprudentially, but even while appointing arbitrators, the Supreme Court has made a significant shift beyond solely appointing retired judges to conduct international commercial arbitrations. As Mr. Fali Nariman aptly put it, we are dispelling the myth that only retired judges make good arbitrators. This evolution acknowledges the wealth of talent among young advocates and arbitration practitioners, including a growing number of women members of the bar today. I've been told by my courtmaster just this afternoon that among the 45 appointments which I've made in the last few months of arbitrators under Section 11, over 23 have been from the bar of the court, the rest being from former judges. If I'm being candid, my initial instinct on the bench was to appoint a retired judge, simply because that is the way we have always done it, a habit rooted in familiarity. But I now find myself taking a moment to pause and tap into India's burgeoning pool of skilled arbitration lawyers with the expertise, knowledge, and skills to excel as arbitrators. Ultimately, it's also a question of supply and demand, and there's so much of work being generated that there is enough for people, particularly young women lawyers, to act as arbitrators, completely displacing the gender imbalance in the world of arbitration. In fact, we are taking a step forward to not only dispel the myth that only retired judges make good arbitrators, which of course they do. I hope Indu will be pacified. Also Brother Rastogi, who is in the audience. But to further experiment with the proposition that good arbitrators also make good judges. And how is that? As arbitration gains traction as a preferred mode of dispute resolution, related litigation is increasing before the courts, requiring judges with specialized expertise. Members of the bar with extensive experience in conducting arbitrations and appearing in arbitration-related cases have been appointed as judges of the high courts in the last few years. Similarly, practitioners with significant experience in international arbitration are increasingly being designated as senior advocates by the Supreme Court of India and by the high courts. On the legislative side as well, the Parliament has initiated efforts to revamp the Arbitration and Conciliation Act of 1996. To this end, the Ministry of Law and Justice has established a committee to review the effectiveness of the Act and suggest amendments. The committee has submitted its report, which is now being acted upon by the Ministry, paving the way for potential reform. In the midst of this unprecedented enthusiasm for arbitration in India, this is an opportune moment to convene the PCA, Supreme Court of India Conference. There was a time when we were fearful of investor-state arbitration. And the reason for that was very simple. We lacked the professionalization which was required to deal with investment disputes between states and between investors and states. That environment has changed with the growing professionalization of arbitration in India. The government of India has been a very engaging partner in ensuring that we train our diplomats, not just in India but overseas, to bring a greater focus on the framework in terms of human resource development needed for pitchforking India as one of the leading participants in the international dispute resolution process. So the fears of white industries and the horrors of the early disputes have now given way to increasing success by India in the international dispute resolution framework. And nothing succeeds as success just as failures provide the occasional blip or setback. I'm hopeful that over the next 2 days we will engage in candid and constructive discussion, tackling pressing questions head-on with the shared goal of strengthening the international arbitration ecosystem. I look forward to the ideas and perspectives that will emerge, both in the formal sessions and in the informal conversations that will take place throughout this conference. We have very distinguished judges of the high courts experts on commercial arbitration who have spared time to come here from different high courts to participate in this conference, because the future really belongs to them. They are the people who are going to really provide mentorship as judges of the high courts and later of the Supreme Court in the field of arbitration. And it is in that hope that we've had this talent of people from the bar and from the bench to come and work with us shoulder to shoulder in making this conference a success. I have great pleasure in welcoming everyone as part of this audience, and I hope our international guests have an engaging period in Delhi and in the Supreme Court over the next couple of days. Thank you very much.
Thank you, Justice Chandrachud, for giving insightful perspective. And I extend my gratitude to all the speakers for their speeches and setting the tone for further discussions over the next 2 days. Over the next 2 days, the working sessions will dive deeply into 3 pivotal areas of arbitration: commercial arbitration, investor-state arbitration, and state-to-state arbitration. In our first day of the working sessions, discussions will revolve around challenges and solutions associated with each of these types of arbitration, as well as issues related to post-award stage. Additionally, we will delve into India's position and involvement in these arbitration regimes. In the second day of working sessions, our focus will be on investment arbitration regime. The speakers will delve into the key investment treaty provisions, essential procedural steps, and the post-award stage, providing an in-depth analysis of each aspect. Thank you all for joining the inaugural program. Tomorrow, the working sessions will start at 10 a.m. I hope to see you all there. Thank you so much. Now, I kindly request all of you to join us for the high tea. Thank you.